The provisions of Section 217E and Section 71AA, along with the explanation thereto of the CGST Act and the KGST Act, which deem the supply of services by a club association to its members as a taxable supply, were declared unconstitutional and void. These provisions were ultra vires Article 246 agreed with Article 366(12)A and Article 265 of the Constitution, as they contravene the constitutional understanding of supply and service, which require a plurality of persons and exclude self-supply self-service based on the Doctrine of Mutuality, as upheld in State of West Bengal versus Calcutta Club. The principle of mutuality, which posits that an association and its members are not distinct entities for the purpose of taxation, survives under the Constitution post the 46th Amendment. The amendments to the CGST-KGST Acts, by statutorily expanding the definition of supply to include transactions between an association and its members without deeming such transactions as services, were beyond the legislative competence of Parliament and state legislatures, as they contradicted the judicially interpreted constitutional meaning of supply and service. A legislature deriving its authority from the Constitution cannot assign a statutory meaning to a term, example supply, that conflicts with its judicially established constitutional meaning. The absence of a constitutional amendment to redefine service to include transactions informed by mutuality rendered the impugned provisions invalid. Although the issue of retrospective operation was rendered moot due to the unconstitutionality of the provisions, the court agreed with a single judge's finding that the retrospective application of the amendments effective from 1 July 2017 was illegal. Retrospective taxation, which imposes liability for a period when taxpayers could not anticipate such a levy or collect tax from recipients, violates the principle of fairness and the rule of law, a basic feature of the Constitution. The state failed to provide adequate justification for such retrospective operation. Writ appeal filed by the Indian Medical Association was allowed, granting consequential reliefs. Writ appeals filed by the GST authorities and the state of Kerala were dismissed.